Welcome to the Ask Junior Daily Judgment podcast. I'm Priya Sharma, and joining me today is Arjun Gupta.
Hello, everyone. We're excited to dive into today's important judgment. But before we begin, don't forget to like, subscribe, and share our podcast if you enjoy our daily legal breakdowns. Your support helps us reach more listeners and continue providing in-depth analysis of the latest court decisions. Now, let's get started with today's case.
Today we're looking at Shri Chandrabhan versus MOIL Limited, a case decided by the High Court of Judicature at Bombay. This case revolves around a key issue, the right to pension benefits for employees who resign from a company versus those who retire. Arjun, can you give us a brief overview of the facts?
Sure, Priya. The petitioner, Shri Chandrabhan, was employed by MOIL Limited for over 30 years. He rose to the position of Executive Director, Technical, and was scheduled to retire in 2023. However, he resigned due to health issues in March 2023, with his resignation effective from April 2023. While he received gratuity and leave encashment upon leaving, he was denied pension benefits under the MOIL Group Superannuation Cash Accumulation Scheme. This denial was based on Clause 7B of the scheme, which states that no benefits are granted to members who resign.
So the core issue here is whether this denial of pension benefits is legal. This brings us to the legal questions involved in this case. Arjun, could you elaborate on those?
Absolutely, Priya. This case hinges on a few key questions. Firstly, does Clause 7B of the MOIL Superannuation Scheme, which discriminates between resignation and superannuation, violate Article 14 of the Indian Constitution, guaranteeing equality before the law? Secondly, is it legally valid to deny pension benefits to employees who resign but meet other eligibility criteria? Thirdly, does the distinction between simple resignation and technical resignation in pension benefits have a rational nexus with the scheme's objectives? Finally, can the forfeiture of pension benefits upon resignation be legally sustainable without a specific provision in the service regulations?
Those are some critical legal questions, Arjun. So what did the court decide in this case?
The court ultimately ruled in favor of Shri Chandrabhan, holding that he was entitled to pension benefits despite his resignation. The court found Clause 7B to be discriminatory and unreasonable.
This is a significant judgment, Arjun. Can you explain the court's reasoning?
Sure, Priya. The court delved into the principle of equality guaranteed by Article 14 of the Constitution. It observed that Clause 7B arbitrarily discriminates between employees who superannuate and those who resign. This differentiation, the court argued, lacks reasonable classification, particularly since employees with similar lengths of service should be treated equally under the law. It further noted that denying benefits based solely on the manner of exit creates an unjust hierarchy among employees and directly contravenes the principle of equality.
That's very clear, Arjun. The court seems to have made a strong argument against the arbitrary distinction between resignation and superannuation. What about the legal validity of denying pension benefits to resigning employees who meet other eligibility criteria?
The court addressed this by focusing on the purpose of the pension scheme. It highlighted that the original eligibility requirements were based on substantial service duration, not the reason for leaving. It reasoned that denying pension benefits to eligible employees who resign can't be justified legally, especially when they have fulfilled the implicit intent of the scheme to reward long-term service.
It seems like the court emphasized the importance of rewarding long-term service, regardless of how an employee leaves the company. That's quite interesting. What about the court's stance on the difference between simple and technical resignations?
The court examined the rationale behind differentiating between simple and technical resignations in the context of pension benefits. It acknowledged that a scheme can differentiate resignations based on intent, for example, resigning to join another company. However, it found no clear justification for denying benefits to employees like Shri Chandrabhan, who resigned for health reasons. The court stressed that such a distinction undermines the objective of recognizing and rewarding years of service, making it both arbitrary and irrational.
That's a crucial point, Arjun. This distinction between simple and technical resignation seems to be a bit vague and can easily lead to unfair outcomes. And what about the court's perspective on the absence of specific provisions in the service regulations regarding forfeiture of pension benefits upon resignation?
The court considered the validity of denying pension benefits in the absence of a clear provision in the service regulations. It found that the service regulations lacked clauses outlining forfeiture of service benefits due to resignation, indicating a framework that protects employee rights and entitlements. The court stressed that a scheme cannot impose conditions contrary to those enshrined in service regulations unless explicitly stated. Denying pension benefits purely on resignation without corresponding regulatory support undermines the recognized rights of employees, particularly when they meet eligibility criteria.
So, Arjun, based on the court's reasoning, it seems clear that the denial of pension benefits to Shri Chandrabhan was an arbitrary and unjustified action by MOIL Limited. What are the implications of this judgment?
This judgment has some significant implications, Priya. Firstly, it sets a precedent for the interpretation of Article 14 of the Constitution, particularly in the context of employee benefits. It underscores the importance of ensuring that any scheme or regulation does not arbitrarily discriminate against employees, even if they choose to resign. Secondly, it reinforces the legal principle that a scheme cannot impose conditions that contradict the service regulations unless clearly stated. This provides a stronger framework for protecting the rights and entitlements of employees. Finally, this judgment may motivate companies to review their pension schemes to ensure they comply with the principles of equality and fairness outlined by the court.
To illustrate the court's reasoning, let's imagine a hypothetical scenario. Imagine a company has a pension scheme that denies benefits to employees who leave before a certain age, regardless of whether they retire or resign. This scheme, just like the one in Shri Chandrabhan versus MOIL Limited, would likely be deemed discriminatory and unreasonable because it fails to account for individual circumstances and the principle of equal protection under the law.
Absolutely, Priya. This judgment highlights the need for greater transparency and fairness in employee benefit schemes.
And that wraps up our analysis of today's judgment. We hope you found our discussion informative and engaging.
Before we sign off, we'd like to remind our listeners once again to like, subscribe, and share our podcast. Your support means the world to us and helps us continue bringing you daily updates on the most important legal decisions.
Absolutely. And don't forget to tune in tomorrow for another exciting episode. Until then, this is Priya Sharma.
And Arjun Gupta, signing off. Thanks for listening to the Ask Junior Daily Judgment podcast.